the kind of violent protests in 2019 was certainly not in the interest of Hong Kong people and was counterproductive. No matter what are the political views of students, the students will have no immunity or exemption from these legal rules. But I think we should tolerate and respect other people's views and never engage in violence. In order for one country to survive, people in Hong Kong will need to think more rationally, more carefully about what is in the best interests of Hong Kong people.
Hey guys, it's Keybros. Welcome to a new episode of SOFTtalk, where unlike BBC's Hard Talk, the interviewees won't find it hard to talk. He is Professor Albert Chen, who is a former Dean of the Faculty of Law of the University of Hong Kong. He is a professor in constitutional law, so he has a very good expertise in the area. And also, he is a member of the Basic Law Committee under the National People's Congress. Professor Chen, do you mind introducing a bit of yourself to our audience?
I graduated from the law school at the University of Hong Kong. That was a long time ago. And so in the 1980s, I started teaching at this law school. So I've taught for more than 30 years.
Thank you very much. Without further ado, let's begin with the first question.
So what do you make of the notion that local universities are hotbeds for subversive activities and radicalism? Do you agree with that notion? And how can we balance academic freedom with ensuring peace and stability in Hong Kong?
I think even in the university, there are students with different political views. So it is possible that some students will have radical political views, but that cannot be said for the university community as a whole. Even before the national security law was promulgated, there are other laws which students have to comply with when they organize activities, such as the Public Order Ordinance, regulating demonstrations, assemblies, and so on. Now, after the national security law was enacted, there are a few additional restrictions. These rules are part of Hong Kong law, so I think no matter what are the political views of students, they should comply with those rules. And so students will have no immunity or exemption from these legal rules. Freedom of thought, freedom of expression, so long as it is not a violation of the law, should be promoted.
So what advice would you give to our young people here in Hong Kong in light of our political divisions and strife and turmoil?
I think differences in political views are quite common in many countries, many places. Now, in the case of Hong Kong, there is also an increase in political polarization in recent years. So students can think about these political issues independently and critically and form their own political views.
Do you think that the actions or the behaviors exemplified by some local university students, not to generalize, but some local university students, reflect that many youngsters in Hong Kong arguably lack critical thinking and lack the ability to form their own individual opinions and instead follow what others tell them blindly?
So if we say that Group A has one view, and Group B has an opposing view. So people in Group A will criticize people in Group B, saying that, well, many people in Group B don't have independent critical thinking. The same criticism will be made by people in Group B against people in Group A. We have to accept that there are some differences of opinion which can never be resolved. But I think we should tolerate and respect other people's views and never engage in violence or even verbal violence.
Yeah, so I definitely agree with that. I think what I was trying to get at is that many youngsters in Hong Kong rely on emotion instead of facts and logic or evidence to reach their conclusions. And it doesn't matter which strand of political opinion they adhere to. As long as they use violence or verbally assault other people and refuse to engage in civil dialogue, I think all three of us here can, universally denounce that and call on them to be more rational in the future. So just a follow-up question to that, do you think it is right or justified or legitimate for certain academic scholars or professors at local universities to encourage their students to engage in illegal acts?
I think it is possible to discuss the theory and the concept of civil disobedience, but of course, inciting any breach of the law, that itself is a criminal offense. So I think teachers or students should not be engaged in acts that will constitute a criminal offense.
We'll now turn to the controversial Hong Kong SAR national security law. Okay, so according to Article 4, it ensures the freedoms and rights of Hong Kong citizens, including obviously the freedom of speech and assembly, as guaranteed under both the Basic Law and our commitment to the International Covenant on Civil and Political Rights, the CCCPR.
So do you think the principle of legality actually applies here, which is the idea that unless expressly provided for, the legislative body should be assumed to have intended for rights to be fully respected?
As far as provisions that are ambiguous are concerned, since the national security law expressly provides for the application of human rights and rule of law principles, so the courts can try as far as possible to give effect to these principles when they interpret ambiguous provisions. This is the usual common law approach to statutory interpretation. But where the national security law has made it very clear how a particular matter should be dealt with, then the court will have to apply the clear language. So some people say the one country, two systems is coming to an end. I don't agree with that. The central government is still willing to continue the project one country, two systems. Whether one country system will work, it cannot be unilaterally decided by either the central government or the people of Hong Kong. It's a question of reciprocal interaction between the two sides. Reciprocal interaction which makes things worse and worse, what we call a vicious circle, then that is the worst scenario. But it is also possible to have positive and beneficial reciprocal interaction. So young people, I think, should make full use of these opportunities provided for by one country, two systems. And that is what I hope will take place in the future.
How can we establish long-term stability, the rule of law, and of course law and order in Hong Kong?
The kind of violent protests in 2019 was certainly not in the interest of Hong Kong people and was counterproductive because in the middle of June 2019, the chief executive has already agreed to shelve the extradition bill indefinitely, and she subsequently also agreed to withdraw it altogether. And despite all this, the protests, including violent protests, still continued. In order for one country to survive, people in Hong Kong will need to think more rationally, more carefully about what is in the best interests of Hong Kong people.
In the case of Lau Kong Yung and the direction of immigration, so the power to make a binding interpretation of the basic law under Article 158, subsection 1, is a freestanding one, and it can be exercised on any basic law provisions, even without reference by the Court of Final Appeal in accordance with the basic law Article 158, subsection 3. So my question is, does the power to make interpretations operate merely on the basis of trust and self-constraint, like in Article 17, where the NPCSC can invalidate Legislative Council laws, but this power is obviously yet to be exercised? Or is this more of a legal boundary as to this power?
Since Hong Kong is not an independent state, so the central government must retain certain powers, but the central government will not easily or arbitrarily exercise this power. It will only use this power where absolutely necessary, protect some important national interests, and to ensure that one country, two systems will not be derailed. The Standing Committee has only exercised the power to interpret the Basic Law 5 times. So you can see that actually the central government has exercised considerable restraint in deciding whether and when to interpret the Basic Law.
So President Xi has actually once said that the constitution of the PRC and the Hong Kong SAR Basic Law together form the constitutional basis of the SAR as a whole. So, of course, there are two different legal doctrines here. So how do you think we can reconcile the differences between the two and to create, for example, the best of both worlds?
Actually, the Basic Law of Hong Kong SAR was promulgated in accordance with Article 31 of the Chinese Constitution, which makes it possible for special administrative regions to be created. Since 1997, most interpretations of the Basic Law were actually issued by the Hong Kong courts. So the Hong Kong courts have actually developed a body of jurisprudence. This body of case law has incorporated many Western or liberal legal doctrines, including the jurisprudence of the European Court of Human Rights. The Basic Law, as interpreted by the Hong Kong courts in the last 23 years, already provides a good example of some kind of synthesis of Chinese legal principles, because the Basic Law was made by the Chinese legislature, and common law and Western jurisprudence.
So in the case of Ka-ling and Director of Immigration, so there's a question of jurisdiction to examine whether any legislative acts of the NPC are consistent with the Basic Law. Should a local Hong Kong court have the capability to scrutinize the acts of China's legislative body or sovereign body, which is the NPC, in your opinion?
In the very recent case by the CFA concerning Mr. Jimmy Lai's bail application, and said that, well, acts of the NPC or NPCSC which were promulgated in accordance with the Basic Law and the procedure cannot be reviewed or declared as invalid by Hong Kong courts.
But do you think this implies that the NPC, on the flip side, may not do anything that contradicts the Basic Law? Whether
a particular act is inconsistent or consistent with the basic law is a question of interpretation of the basic law. So since the NPC Standing Committee has the power to interpret the basic law, it can be inferred that when the NPC or NPCSC promulgates any particular act, the NPCSC would already have considered whether that act is consistent or inconsistent with the basic law.
So public emergencies are commonly used as a reason to justify derogations from a jurisdiction's obligations, such as in the European Convention of Human Rights, ECHR Article 10, Section 2. So this was accepted as legitimate in the CFH judgment on the anti-mask ban. So are you concerned by this judgment in the sense that it might set a precedent for further curtailment of our civil liberties? Or do you agree with the principle adopted by the CFA?
The Emergency Regulations Ordinance is an ordinance which existed in colonial times. It continues to have force after the handover. So under this ordinance, the executive, that is the chief executive in the executive council, can promulgate emergency regulations in times of emergency or so-called public danger. But the CFA also pointed out, as the lower courts have also done so, that whether a piece of emergency regulation is valid still depends on whether the restrictions on rights that it contains are excessive. So if the restrictions on rights are excessive, then the so-called proportionality test can be used to declare those restrictions to be unconstitutional.
So speaking of, this conflict or synthesis between the Chinese constitutional system and the Hong Kong one point of contention would be separation of powers, because obviously the mainland does not recognize this doctrine and sees it as purely Western. For example, in the mainland, the judiciary is staffed with party members, and they observe the doctrine of democratic centralism. Instead of separation of powers. So do you think separation of powers actually exists in Hong Kong? Because our position is that separation of powers is merely an academic concept, and while we do have checks and balances, there is no pure system of separation of powers to be found in any countries, including the UK or any other jurisdiction. So do you agree with this characterization of Hong Kong's system?
I think the debate about separation of powers was mainly a debate about the Chinese term, 三權分立. If you look at the latest statements of the license office, they actually have no objection to another term called 三權分治. So I don't think that there is an objection to the concept of separation of powers. There is only an objection to this Chinese term. Now, the Chinese government's view is that the Hong Kong political system is executive-led, and that is why it doesn't agree that 三權分立 should be used to describe the nature of Hong Kong's political system. Actually, the concept of separation of powers can be seen Mr. Ji Pengfei's speech in 1990 when he explained the draft basic law to the NPC. He said that the political system of Hong Kong SAR is based on the idea that the executive and the legislature should exercise mutual check and also coordinate mutually with one another. And he also said that the judiciary should be independent. So that is more or less what we understand to be separation of powers.
So thank you very much, Professor Chen, for coming on to our show. It's a huge honor. And we really learned a lot from today's interaction, as I'm sure for you viewers. So yeah, please stay tuned to our channel, give it a like and also subscribe to it by pressing the red buttons below. And see you guys in the next episode. All right, bye.